Welcome to this talk, which is a personal injury liability update, looking back at developments over the past 18 months or so. I'm David Roderick and I specialise in PI and clinical negligence at Farrar's building. I should point out to you that there is a written Q&A function on the Zoom. I'll attempt to answer any questions if there is the time at the end. We do have quite a lot to get through. I'm conscious we are starting at the end of the day. So of course, I'm very happy to follow up questions by email, and the webinar and the slides will be available to you to access on request. So two parts to the talk. Firstly, developments that are of general application in the law of negligence, but have particular effects in personal injury claims. And there are three aspects to that part of the talk. Firstly, there have been a number of cases whereby claimants have sought to establish a duty of care where a defendant has omitted to act. Secondly, cases which continue to define the circumstances in which vicarious liability might attach. And thirdly, a potentially significant development in the interpretation of the control mechanisms that the court uses to limit the ability to claim damages for psychological injury as a secondary victim. And then the second part of the webinar, as you'll see from the slide, I'm going to provide some case law updates from the major practice areas that we deal with often, highways claims, employers liability, PL and RTA cases. So turning first to identifying the existence of a duty of care in negligence, just a brief reminder of developments over the past 2 years might be useful. The proper approach to identifying the existence of a duty of care was, of course, clarified by the Supreme Court in two cases recently, Robinson and then subsequent to that, Poole. And following on from those decisions, the main cases which we need to be aware of have principally then dealt with arguments about two concepts. Firstly, a defendant's omission to act. So whether the omission is a failure to prevent harm caused by a third party, or whether it's just merely failing to confer a benefit. And the former might ground liability and a duty of care, but the latter wouldn't. And secondly, an argument where it's argued that the defendant has assumed a responsibility to the claimant, assumed a responsibility to protect from harm caused by a third party. And these reported cases, which we'll look at, arise principally from the first line of defence to a novel duty of care argument, and that first line of defence would typically be a strikeout or a summary judgment application. So Robinson, you'll remember, that was a claim against the police when they arrested a person on a busy shopping street and a passerby was injured. And it was held in that case that there's not a general duty on the part of the police to prevent harm. So omitting to act does not usually raise a duty of care, subject to some exceptions, which we'll come on to. But properly analysed, Robinson wasn't actually an omissions case. The police had taken positive action because they decided to arrest on a busy shopping street, and they'd done that having foreseen the very risk which then occurred. So subsequently, there was the case of Poole, which was quite a curious argument on the part of the claimants, because they were arguing that the local authority was liable in damages for failing to remove them from their family home because they had a noisy, abusive and disruptive neighbour, causing psychological harm to the children. And the claimants argued that the local authority had assumed a responsibility to prevent that harm occurring. It was decided that there was no general duty to confer a benefit by protecting the claimants from harm, but the liability of the local authority could rest on a failure to act if the authority had created the danger itself, or if it had indeed assumed responsibility on the basis of providing services and thereby providing an express or implied reliance on the part of the claimant on those services. In the case of Poole, investigating and monitoring the children after the complaints about the abusive neighbour were made weren't deemed to be the provision of a service on which the claimants could have expected to rely. They were just exercising statutory obligations, and so that was not an assumption of responsibility. So moving to the more recent case law on the bedrock of those principles, defendants' responses to novel duty of care arguments can be seen in the following cases, and they're cases where strikeout applications have been made. Firstly, transport arendonk. It's not actually a personal injury case, but it's useful for applicable principles at least. In this case, the driver of a vehicle was arrested and his vehicle was left overnight in a lay-by that the police knew was plagued by thieves. The police also knew that the curtain side of the lorry had a hole in it, and the police didn't allow the driver to make a phone call to arrange for its security, and therefore the goods left inside overnight were stolen. Now, plainly, there isn't a duty on the police to protect a claimant from harm caused by third parties generally, but the claimant said that the police had created the harm themselves via a positive act, or at the very least had assumed responsibility for the security of the contents of the lorry. And the strikeout application made by the police wasn't successful at first instance, and that same decision was upheld by the High Court. It was plainly the case that an assumption of responsibility was arguable in those sets of facts. So moving to what was a personal injury, a fatal accident case, and a similar argument recently applied, Tyndall. The police attended at an accident, a road traffic accident that occurred because of black ice on the road, and the police put out warning signs. A victim of the first accident then informed the police, because he was a road gritter, coincidentally, he deemed the road to be exceptionally dangerous because of the black ice and it should be shut. The police didn't do that. They cleared up the debris from the first accident and they removed the warning signs, and then they left, and the black ice remained in situ on the road. A second accident ensued and a person died from their injuries. The strikeout application on behalf of the police, the claimant argued that the police had either intervened and made the situation worse, and that would be a positive act, like in Robinson, or that they had assumed responsibility for the safety of the motorists coming along after by having been there at the first accident. And Master McLeod refused to accept the police's argument that those assertions were bound to fail. And if anything, I think that's a case that's illustrative and reminds us all again of the fact that there's quite a high threshold, isn't there, for a strikeout or a summary judgment application. And so we moved to last year and a certain number of decisions. Firstly, DFX. This is a case that drew together the tests for identifying a duty of care in negligence. And it's, again, a failure to commence care proceedings claim. It set out the principles that we've already discussed. And I'm going to focus on E in this slide in front of you. The judge set out these factors that are effectively the gateways for a claimant to establish a duty of care in a case where the defendant hasn't acted. So otherwise, other than through those gateways, not taking any action in the sense of failing to prevent harm from a third party won't generally found a duty of care. And finally, and even more recently, in November of last year, HXA and YXA were appeals that were held together. They were cases that involved both of them failures to remove into care, and both of them involved the claimants arguing that the local authority had assumed a responsibility by the interactions that the local authority had already had with those children. Effectively, in both cases, Mrs. Justice Stacey decided that the steps that the claimants were relying on that had been taken by the local authority to found an argument about assuming responsibility were in fact omissions. They weren't positive acts. The authorities properly analysed were being alleged to have failed to prevent harm caused by other people, i.e. the perpetrators of some abuse. The local authority were not directly causing harm themselves. And so the analysis then moved on to what the exercise of the statutory duties had been on the part of the local authority and what had occurred through the exercise of statutory duties was determined to not have been the provision of services. Services were not being provided directly to the claimants in a way which might then create an assumption of responsibility. That was effectively the ratio in both of the appeals. What's of more general importance is the statement that this is therefore not a developing area of law in relation to public authority or local authority liability for failure to remove type cases. If a matter is susceptible to an argument that it's a developing area of law, that's one way, of course, that a claimant can typically perhaps defend a strikeout application. But that's a quite bold statement that the provision of these type of local authority care statutory obligations and duties are not grounds for an assumption of responsibility for a duty of care argument, and therefore they are susceptible to strikeout applications. So that can all, the threads of that can all be joined together to perhaps say the present position is one of a tightening up of potential liability in novel duty of care type arguments, and probably a more favourable position for defendants. And it is also worth pointing out that the novel arguments in front of the courts over the past couple of years are being run not only in respect of public authorities. So the case of Rush Bond, again, this is property damage and not personal injury, but the claim was struck out when it was asserted that an architect had assumed responsibility after having keys to a premises and going into it and not being able to prevent a burglary that occurred, or I think an attempted arson and burglary when the building was unlocked. There had been no assumption of responsibility in those circumstances. But contrast that with a case from last year of Begum, where the claim was not struck out on an application for strikeout. This was a fatal accident at work case where the deceased was breaking up a ship in a Bangladeshi dockyard, and the claim had lots of difficulties with jurisdiction, but the claim against the company who arranged the sale and disposal of the tanker in the first place wasn't struck out. It was arguable that the claim against that company fell within the creating a danger exception to the usual rule of there being no liability for failing to prevent harm. So moving on to the second area of general application, but with particular effect in the personal injury realm, vicarious liability, being fixed with liability for another's act. It's again worth just a quick recap of the two stages of the test to establish liability, because that will set the context for the cases over the past couple of years. Stage one, as we all remember, the defendant has to be in an employment or akin to employment relationship with the tortfeasor, and stage two, there has to be a close connection between that relationship and the wrongful conduct. And so you'll recall that in the years leading up to perhaps 2020, there was potentially an expansion of this doctrine of vicarious liability in the way that it might have affected insured defendants. In the first case of Cox, concerning stage one, a relationship akin to employment extended to a person who was within the economic function of the defendant, not an employee. For example, in that case, it was a prisoner doing work for the prison and therefore the Ministry of Justice. In the case of Mohammed, where a customer services attendant assaults a customer, that concerns, of course, stage two of the test. The tort committed could be sufficiently connected to a relationship with the defendant if it was connected to the field of activity of the defendant, a field of activity of employment that was ongoing. The test not actually limited to the tort being actually carried out within the course of employment, which obviously an assault couldn't be said to be. There was then a reclarification, arguably a contraction, of the application of the vicarious liability tests in early 2020, and the case of Barclays, firstly, in relation to stage 1 again, where the distinction between an employer-employee relationship and an independent contractor relationship was very strongly reinforced. You'll recall that a doctor in that case was undertaking health checks for Barclays, and he was effectively in business on his own account. He was a classic independent contractor, notwithstanding that it could be said that there was still contractual control that Barclays exercised, retained. Barclays still exercised and retained over him. And also at the same time, a case of Morrison supermarkets. This related to stage 2 of the test. There'd been an unlawful leak of confidential data by an employee. So stage 1 was met. It was an employee who leaked the data. The employee was allowed to access and manipulate that data in the ordinary course of his employment, but he was obviously not authorized to wrongfully disclose it. And that wrongful disclosure was found to not be sufficiently connected with his employment. And one has to contrast that, if we remember back to Mohammed, an assault by an employee was sufficiently connected, but this wrongful disclosure of data was not. And that has therefore become the really important line of defense for any defendant to distinguish the mere fact that an employment relationship or scenario gives the tortfeasor an opportunity to commit the wrong. That does not equate to, on its own at least, a sufficient connection of the wrong to the relationship. And we can then move forward in time to last year and decisions that follow on from that backdrop of the Supreme Court authorities. And a case of Hughes and Rattan. The recent application of the clarified vicarious liability test can be seen in this case. This deals with stage 1 in particular. So the case involved self-employed dentists who were all grouped together at a dental practice. On the one hand, they were people who were able to decide when they worked. They made their own clinical decisions. There was a lack of control, therefore, from the dental practice of their work. But on the other hand, the practice took a percentage of their NHS payments. The practice enforced health and safety type policies and set the opening hours and took the bookings. So if we compare that to Barclays, the doctor running health checks as an independent contractor, could the dentist be called independent contractors in this case? I think Hughes and Rattan illustrates certain factors that are taken into consideration in that question, and it illustrates that that question is always going to be a very fact-sensitive one in every case, because here the arrangements were sufficiently akin to employment to impose vicarious liability. Shell and Tarmac Cement deals with the application of the principles, but in relation to stage 2. An employee who perpetrated a practical joke, using a joke quite lightly as a term. The employee set off an explosion next to a work colleague, and that damaged his colleague's hearing. And the claimant argued in that case that there was a seamless chronological episode between the employees properly working on the equipment that then was used to set off the explosion in the course of their employment and the prank that then occurred. But the dismissal at first instance of the claim was upheld on appeal because there wasn't a sufficient close connection just because you could say that there was a chronological connection in time. That simply is another way of stating the mere opportunity for the employee to commit the wrong. And so I point out Shell and Tarmac Cement in particular as a case because I think that's a likely useful case for defendants in the future in particular. And in completing our overview of developments in terms of vicarious liability personal injury cases, we need to draw our attentions to vicarious liability in the historic abuse realm. I'll mention SKX, where the local authority was not vicariously liable for abuse in a care home that was run by an independent contractor. Moving to the case of the Barry Congregation of Jehovah's Witnesses, it's important to note, firstly, in relation to stage 1, a person who is a volunteer can still satisfy that akin to employment test, even if it's a volunteer. And for stage 2, an important principle to take from this case is that the close connection test between the tort and the work is likely to be a tailored test in abuse cases, and in particular in spiritual congregation type cases. So inquiring into the relationship between the loosely termed work, the authorized work, and the wrong that's perpetrated. The work is often going to be spiritual guidance, creating a dependency. It's not just the creation and production of goods or the provision of services. And those two cases then bring us very much up to date with 2 cases where claimants haven't been successful in running vicarious liability arguments. First of all, DSN, where a volunteer football scout organised overseas tours for Blackpool FC youth players, with the involvement of Blackpool FC to some extent. But the principle that has been applied latterly from DSN is that for the relationship between a defendant who it is claimed is vicariously liable and the tortfeasor to be one that's akin to employment, you need to actually identify more than just a mutually beneficial involvement with each other, with the tortfeasor and the defendant's enterprise. You need to be able to establish a real degree of integration within the enterprise of that tortfeasor. And that brings us very much up to today's date almost, because on Monday, the result in the case of TVZ and Manchester City was made public. It was a claim about Manchester City's liability for the abuse perpetrated by Barry Bennell, and the claim failed on limitation, but it also failed on both stages of the vicarious liability test. And that was firstly because properly analysed, Bennell's relationship with the club wasn't one that was akin to employment, and further, the abuse that he perpetrated had been done in his own home, and that effectively was removed from, not sufficiently connected to, authorised work, which wasn't supposed to be done in his home at all. So I'm briefly going to recap the principles in relation to our third view of general developments. We're looking at the secondary victim claims now. There's of course a right to recover for psychological damage in the absence of a physical injury as a result of merely witnessing rather than being a primary victim of a negligently caused trauma. But that's subject to control mechanisms. For example, close ties of love and affection, directly perceiving the event that occurs, and proximity to the traumatic event or to its immediate aftermath. And those control mechanisms from Alcock have subsequently been developed and expanded a little in relation to their restrictive control in the cases of Taylor and Somerset and Taylor and A. Novo, which have resulted in requirements to establish a secondary victim claim that the negligent breach which is alleged has to have caused an external traumatic event that's been perceived that immediately causes an injury. And secondly, that in thinking about the proximity to the traumatic events test, the proximity which is measured has been applied to the breach event, what the defendant did wrong, and not the later consequence of the breach event. So if someone becomes ill or is injured and that eventuates at a later date. So thus we come to perhaps 2 of the most interesting cases of the last year and a half. First of all, Paul. Paul and the Royal Wolverhampton NHS Trust. So we're thinking about clinical negligence cases in particular in relation to the problems that arise with secondary victim claims. In Paul, the breach event was a failure to disclose. Forgive me, I've misspoken. A failure to diagnose a heart condition. But 14 months after that, there comes the traumatic event. There's a heart attack that's witnessed by the claimants. And at first instance, the secondary victim claim has not been struck out. It's not been struck out because it's viewed as arguable that the past authorities don't provide that the relevant event, when you're trying to measure and decide proximity to an event, has to be actually synchronous with the negligence event. And the case of Taylor, which suggested that might be the case, has been distinguished in Paul, because in Paul there's only one traumatic event that's relied on by the claimants, only one traumatic event for the court to consider, and that's the witnessing of the heart attack. There wasn't effectively anything to witness in relation to the breach event, which is a failure to diagnose. And that's to be contrasted with the earlier case in the case of Taylor, that the pleaded traumatic events there were numerous. There was a progressive decline. There were traumatic events, upsetting events at a hospital, and then there was the eventual death. And Paul is being considered alongside another case called Polmere and Royal Cornwall Hospital NHS Trust. And again, the case arises from a defendant's strikeout application. And again, that application has been dismissed at first instance. The breach in Polmere was a failure to refer a child for treatment. And again, the traumatic event occurred some months later because the claimants witnessed a failed resuscitation and unfortunately the death of their child. But between those points in time, the failure to refer for treatment and then the eventual death, there had been various cardiorespiratory episodes where the deceased had sort of suffered discomfort. So there could well be an argument that there wasn't only one end traumatic event that's being measured, as there had been in the case of Paul. But at first instance, the court held that the final event that was relied on, the failed resuscitation and death, was capable of being the relevant event for the purposes of the Alcock control mechanisms, even if it wasn't actually the first event in which there was any actionable damage, which could have been alighted on by the claimants. And Paul and Polmere were the appeals in front of the Court of Appeal were heard on I think the 14th and the 15th of December of last year. And I checked today, and I don't think there's and we don't have the judgments from those yet. But that is a potential real development in the control mechanisms, or at least certainly an authority that will consider them, and we must keep our eyes out for. And finally, in relation to secondary victims, there was a case last year called King and Royal United Hospitals Bath. The case relates principally really to the threshold for the definition of shock from a horrifying event in relation to establishing a secondary victim claim. It is, of course, horrifying in the ordinary sense of everyday language to be told that your child might die and to witness your child in the ICU. But that information and witnessing your child in the ICU was not deemed to be an objectively horrifying event that leads to a sudden shock in the Alcock control mechanism sense. And so the claimant failed in that claim. So we move then to sort of part two of the update, where we look at particular practice areas. And I'm going to begin with 3 Highways Act cases. I think it's useful to draw your attention to them, but perhaps for the purposes of time, I won't go through them in very fine detail. The first case is Barlow and Wigan Metropolitan Borough Council. And the factual scenario there was a trip on a path in a park, and the path had been there for many years, since before 1930. It was agreed that it was a highway, and so therefore there was no occupiers liability in relation to the path in the park. The question for determination really became, was that therefore a highway that was a highway maintainable at public expense, and therefore it would be subject to the duty to repair under the Highways Act 1980. And the Highways Act 1980 section 36(2)(a) has a definition that a highway maintainable at public expense, which is one which will be subject to the duty of repair, includes a highway constructed by the Highway Authority. And the ratio of this case is effectively that subsection needs to be read as a highway maintainable at public expense includes a highway constructed by the Highway Authority exercising its highway functions. And in that case, the claimant was able to establish that indeed it is how the highway was constructed many years ago. A situation perhaps more likely to be more often encountered is the situation in Smithson, because this involved the Highways Act section 41(1)(a) snow and ice provisions. So the Highway Authority has an obligation to take reasonably practical steps to ensure the safe passage along the highway is not endangered by snow or ice. And that, of course, is not an absolute obligation, but the burden of proving what is reasonably practicable is, or not, is on the Highway Authority. And that case is useful to look at because it delineates the arguments on either side, balancing that exercise of risk of endangerment versus the resources of the Highway Authority and the practical arrangements for dealing with snow and ice. And then I'll move to the case of Murphy. And again, this is probably a useful case for defendant, highway authorities and occupiers to look at. It's another relatively common scenario where the defect overlaps the boundary of the highway. You may be able to hear a printer going off in the background. Apologies for that. Moving to public liability and occupiers liability 1957 cases, what's most useful to highlight, I think, in this regard are a number of cases over the past 18 months in respect of activity that's done under the duties that are in the Occupiers Liability Act 1957, when we think about things done on the land as opposed to purely the state of the premises. And the decisions have really focused on the adequacy of risk assessing and safety measures for events that are taking place. And that's been the claimant line of attack. The causation defence is still available after a failure to adequately risk assess, and that's been a defendant line of defence, which we'll look at. And also defendants have run arguments in relation to the social utility of the event, and so also utilising Compensation Act provisions, for example. And so we can illustrate that by a case called Wells and Full Moon Events, and that was a case of an off-road motorcycling event where the claimant rode his motorcycle into a puddle that struck a rock, and the wheel struck a rock, and therefore he was injured. And it was held that the assessment that was done in that case wasn't required to be so detailed as to identify and guard against every single hazard that could have occurred on the terrain, because effectively hazards on the terrain were inherent in the experience. So no breach because of that decision. Similarly, Duggan and bike events, similar type of activity. This moves us into considering the usefulness for a defendant, at least, of a causation argument. There's a road cycle race that occurs, and it's on an open course. So road traffic is on the cycle course. And the claimant went too wide at a blind bend, and a car coming in the opposite direction hit her. And so what was in issue was effectively the adequacy of the signage warning of a risk from the bend up ahead. And there were competing arguments as to the adequacy of the assessment and the measures that were taken. And the claimant ultimately succeeded in establishing that the race hadn't been properly assessed, at least not at that point on the road. But that wasn't a causative breach, because even though it wasn't a proper risk assessment, to fail to have considered that aspect of the risk, the court concluded that a reasonably conducted risk assessment would have reasonably concluded that no additional signs were in fact necessary. And so the claim thereby failed. And another case, also of last year, similarly, is Harrison and the Bear Grylls experience that was offered. That effectively makes the same points that I've just covered. So those three cases are perhaps quite useful for defendant insurers in particular. I can move to James and the White Lion Hotel, and it might be said that this is a more favourable case for claimants to read. You might remember that the claimant wanted to smoke a cigarette, and so had to hold open and I think effectively perch or lean out of a broken and very low level window, low level in the room that he was in, but the window was on the first floor. And so the defective window and the fact that the window was so low and beneath building regulations and height standards meant that there was a breach. But of course, the claimant ran a very obvious risk by leaning out of the window so far to smoke and having to sort of hold it open and perch at the same time. There was, of course, a finding of contributory negligence against those facts. But the court didn't accept the full defence that was available under the Occupiers Liability Act, essentially a Valenti type argument. The court determined that the claimant's actions in leaning out to smoke didn't mean that he knew of and accepted the risk that was caused by the breaches of duty that had been found, and certainly not that he'd done so to the degree that absolved the defendant of the liability for those breaches. That illustrates, I think, that I think it's section 2.5 of the Occupiers Liability Act that provides for that Valenti defence. It is quite a high threshold in terms of resisting liability. Moving to recent employers' liability cases, Moira is probably an overlap case between occupiers' liability and employers' liability. I think the point of general application to take from this case is that the specific requirements of the construction, design and management regulations were not imported into the common law duty that an occupier or a head client who has an independent contractor employing the injured claimant has to keep in mind or has themselves fixed with the standards of duty of. Secondly, in relation to employers' liability cases, it is a case of Needle and Swallowfield, and this again is a useful case for a defendant employer facing a manual handling claim. The case effectively reiterates that not all conceivable handling tasks can be individually risk assessed. A defendant employer has, of course, got to face the fact that if there is a foreseeable risk of injury, then a manual handling task should, in the first instance, be avoided. But if it can't be avoided, then measures need to be taken to reduce the risk. And what this case helpfully illustrates is that when considering whether there is a foreseeable risk of injury, such as to trigger the manual handling regulation obligations, that risk has to be assessed within the particular occupational context that one's looking at. And here in Needle and Swallowfield, that was relevant because there was a really quite large and fulsome training and instruction process taken by the defendant employer. There was a generally safe system there was an experienced worker who could be shown to have asked for help in the past with a policy that help could be asked for and answered by other employees. So the actual operation that the worker was carrying out when injured, which was awkwardly lifting a heavy object that had been risk assessed in other ways, that in fact wasn't an operation that carried a foreseeable manual handling risk in the context of that full system of training and assistance that was generally around it. And finally, in relation to employers' liability, we still await a Court of Appeal decision in respect of how to deal with the sort of obligations in terms of defective equipment in the equipment regulations, and the effect on that of the removal of civil liability and post error. A possible route to liability, of course, remains the Employers' Liability Defective Equipment Act. But of course, it needs to be remembered that a claimant's still going to have to establish fault. Evidentially, the claimant will bear the burden of showing that a failure or a break of equipment that their employer held was the fault of a third party. 2 county court cases have dealt with that argument on their own specific facts, and you may well have been involved in examples of your own. And I think then that brings us to road traffic accidents and updates in relation to liability decisions, which themselves include some points to note in relation to evidence and expert witnesses, which are of general application. And then also we'll look at some contributory negligence cases with children involved. Some quite small writing on the slide. Sorry about that, but I hope that this breaks down the cases into a digestible form. We look at first Vincent and Walker. It's a pedestrian stepping out case. I would say it's relatively unhelpful to claimants and relatively helpful to insurers. Each case will turn on its facts, but the facts in this case were that a driver was driving at around about 40 miles an hour, 10 miles per hour below the speed limit, and the claimant crossed at the second section of a pedestrian crossing and crossed on a red signal and departed from that central refuge area without looking properly. It was found in that case that a driver driving at that speed was permitted to rely on an adult pedestrian using the traffic lights before they crossed, or at very least checking before stepping out that the road was clear. Secondly, YYY and ZZZ. This is a case that could be said to be more helpful to claimants. It's a claimant who, well, actually, this is more helpful to claimants. The claimant in this case was making a contribution claim against the motorcyclist. So it's a case that will be helpful if you are representing a claimant motorcyclist and you're resisting a contributory negligence defence. But in these proceedings, a driver is making a contribution claim against the motorcyclist in respect of the motorcyclist's pillion passengers claim, because the motorist had originally performed a U-turn and alleged that the following motorcyclist should have slowed down and avoided it. And effectively, that was deemed to be a counsel of perfection to say that the motorcyclist should have avoided the U-turn happening in front. Also last year, the case of Collins and Goetz. This is an interesting pulling out case. It's interesting because the driver who's driving on the main road and within the speed limit was actually found 30% liable for not slowing down and also allowing his attention to become focused elsewhere after he'd noticed that there was a car waiting to pull out of a minor road ahead. And of course, there are circumstances where that's perfectly reasonable, but perhaps it's quite uncommon. The driver who was on the main road in this case was found not to be entitled to assume that the other driver would not do something foolish, and that the other driver would not pull out. And in terms of causation, it was found that if the driver on the main road had reduced speed by not a significant amount, that slowing would have avoided the collision. And I highlight the case also because it's worth noting in the case some comments about the limited reliance that a court can place on accident reconstruction evidence, which has relied on research papers rather than on an assessment of the physical evidence in the case. And that's something which perhaps repeated or expanded a little on in the case of Parker and McLaren. It leads on to this case, really. We return back to the circumstances of a pedestrian stepping out case. And the stepping out occurred in the context of a busy Saturday night town centre scenario. And the defendant driver is a taxi driver who knew of the risks of pedestrians stepping out after exiting pubs and clubs. And the taxi driver was driving at 20 miles an hour. And that was found to not be a reasonably safe speed in the circumstances, even where there was a 30-mile-an-hour speed limit where the accident occurred. So in that regard, not particularly helpful for defendants facing cases where there's an allegation of unreasonable speed, even when well within the speed limit. But it's worth looking at for some helpful comments that reiterate the primacy of contemporaneous factual evidence and the importance of not elevating expert evidence into a framework against which defendants' actions are to be judged with mathematical precision. And that quote's from quite a well-known case, Stewart and Glaze. One might mention a case called Ahanonu, and similarly the sort of the counsel of perfection, which is to be avoided when you're looking at things in a courtroom as opposed to in the moment, in the real life scenario. And it itself also picks up from the next case in the slides, which is one that was heard last year, Barrow and Merritt. The primacy of contemporaneous reporting as opposed to evidence which develops over time innocently or otherwise, but can be innocently, certainly through the context of litigation. And contributory negligence and children, there have been a couple of interesting cases at least over the past 12 months about that issue. First of all, Gull and McDonough. There was quite a helpful recitation of the principles to apply in respect of determining contributory negligence in this case when having to consider the behaviour of a child. Of course, the court in these circumstances has to determine what, on an objective basis, could reasonably be expected of a child, but that's a child of the same age, the same intelligence levels and the same life experience as the claimant. So an objective test looking at subjective features of the claimant. And in this case of Gull and McDonough, the claimant was wearing headphones when crossing the road. So quite a common scenario now and in the future. And so that meant that the claimant didn't hear the speed of the engine of the car that was approaching. The claimant saw the vehicle approaching, but as a 13-year-old, had failed to appreciate the speed of that vehicle. It was determined that a reasonable 13-year-old would in fact have realised that the car approaching was speeding and would have waited. And in addition, if having stepped out, would have kept monitoring and kept the car that was approaching under assessment and hurried up and sped across, and in terms of causation would have got across the road before being hit in the collision. So a finding of contributory negligence was made. In terms of the percentage applied was a 10% reduction of the value of the claim. That I think effectively was because the defendant driver in that case was really massively blameworthy, to put it bluntly. I think recklessly driving away from a crime. And we come to the case of Liability a few months ago, and the perhaps other side of the coin in thinking about the assessment of what might reasonably be expected. This involved an injured 9-year-old, and the 9-year-old had relied on the group she was with, inclusive of adults and I think inclusive of her mother. And the group began to cross the road at a crossing, but against a red light to pedestrians, under the impression that nothing was coming. Of course, a vehicle was approaching. During the crossing, the 9-year-old got ahead of, by a metre or so, the group that she was with, and became distracted and didn't realise that the group was stopping, or indeed trying to warn her to stop as well, in light of the oncoming vehicle, and a collision ensued. But there was a finding of no contributory negligence on the part of the 9-year-old, who was entitled to rely on the actions of the adults, and who was not at fault for becoming distracted when she was walking across the road after having relied on them. So I think we've gone at quite a canter through what I wanted to deal with and what the slides deal with in full. And that therefore is the end of the webinar slides. However, I note from the Q&A we might have some questions, and there are a few minutes left to deal with them. I'm just opening up. Well, I've been informed by someone who's been able to look at a Court of Appeal decision that in Shell the appeal was dismissed today. That's really useful comment, and sorry not to have picked that up whilst I was preparing the talk today. I did quite nervously look at Paul and Polmere. I've got a couple of questions which seem to relate to a specific case that I haven't mentioned, and I will attempt to answer those, as I say, by email. Yes, and that's repeated as a question. And a case on a manual handling scenario in terms of, I'll read out their question. What are my views on the necessity of a tail lift for removing large items from the back of a lorry? Do I think it's a reasonably practicable step which should be in place to reduce the manual handling risk? And I think that might be in the context of a large client, which I'm going to take to mean a client that has some resources in terms of a business, and that client has a number of claims which involve injuries when removing items. Yes, and so I mean, the issue is there fact-sensitive cases, and so what is the cost of putting in a tail lift on the fleet of lorries? It's presumably not small, but if you represent a large international company, they could finance it and resource it in the light of receiving what I haven't read out, but the question implies there are quite a lot of claims that come their way because of the fact that people are injured because they say there's not a tail lift. And if there are quite a lot of claims, then one might say that it is obviously a reasonably practicable and proportionate step to spend money. I would have thought that if you're on notice of a lot of injuries occurring in one particular way, then that's obviously foreseeable that injuries will be caused in that fashion. And although liability, civil liability in relation to the breach of the statutory employer's duties no longer exists, if you can reasonably foresee injury, you're on notice of injuries happening in a particular way, and it is not impossible, a very high threshold to in some way mitigate against that risk, then I think most courts are going to find that you were under an obligation to put in place some mechanism to avoid that manual handling by the way of a tail lift on the back of a lorry. So my answer to that, perhaps in quite a rambling way and not giving away everything from the question, is that I think if that particular client is avoiding running cases to trial, that might be wise. I've got a question on the RTA cases in relation to physical evidence of speed other than the assessment of the parties at the time in the witness evidence. I'd have to look at each of those individual cases and the evidence in them. But what I would say about, there are arguments in a number of fashions, aren't there? If you have CCTV evidence that a diligent accident reconstruction expert can look at and determine speed, that is very good evidence. It's challengeable, and that's probably going to be better evidence than eyewitnesses who can give their impression of speed. But there are equally other cases where you don't have CCTV, when you have witness evidence that in fact will probably be decisive. The witness evidence given to the police in the report at the time by an independent third party assessing speed, and that independent third party providing a witness statement disclosing the fact that they're a professional driver or they've driven for a long period of time and they're otherwise not vulnerable to challenge in terms of the quality of their evidence, that is very useful evidence. Okay, so there are a couple of other questions, but I think I have run out of time at 5:30. I shall attempt to answer any emails that come, and I'm going to put up onto the screen now. You should be seeing my email address. That will be available to you on request as well if you don't manage to copy it down or screenshot it. But in the interim, I'll say thank you very much for attending, and good night.